Hi, I'm John Strohmeyer, and today we're talking about declarations of guardians for yourself. So we've talked before about statutory durable powers of attorney and medical powers of attorney. Those are documents that allow you to name somebody as your agent when you are either have capacity to act on your behalf for certain financial transactions, or somebody who can be your agent to transact business and make medical decisions for you if you've lost capacity. While we use these forms to make sure that people can ensure a continuance of decision making, sometimes we get into the situation where we'll need an actual guardianship set up for a person. Well, in this case, the Texas law allows you to name the people you would like to be as your guardians. It'll also allow you to name the people that you don't want under any circumstances to be your guardian. So typically what we'll see is we're naming people as the guardians who, if something happens to you and you lose capacity, who do you want making those decisions for you? Now, this lines up in two types of guardian. There is the guardian of the person, who's generally going to be responsible for things like food, clothing, and sheltering decisions. And there's also going to be the guardian of the estate, who's responsible for managing the assets of that incapacitated person. So you can have two different wards, a guardian of your person as well as a guardian of your estate. They can be the same person. They don't necessarily have to be the same person, and ultimately a probate court's going to review the evidence and see, if who's the right person to be appointed, because by appointing this guardian, you're making sure that a guardian can act, and they act in the stead of that ward. And that means that those rights are being taken from the ward and given to the guardian. And this is a legal transfer of rights. If you want to think about it in a different way, when you were a minor, your parents were your natural legal guardians, meaning they effectively served as your guardian of your person. They had all the rights to determine where you lived, what you wore, where you went to school, and where you, basically what you did with your day. But if you owned any property, they weren't the guardians of your estate. Now, we put this together because it's still possible for an adult to lose capacity. Generally, this will happen as part of the aging process. It may be spurred on by later disease, such as Parkinson's, dementia, or Alzheimer's, in which case an adult may need to get their own guardian later on. So what this declaration of guardian for themselves allows is for a person to say, if I lose capacity and you have to take my rights away and give those rights to somebody else, I want to name these people to be the person in charge of my rights. You can also exempt or exclude certain people from serving as your guardians, and once appointed, those people will be legally responsible to the probate court to take care of you and manage your assets.